Naiomi, thanks for being with us. To start, what's your reaction to Minister Lafreniere's comments today? And can discussions with First Nations be productive when there's an ongoing court challenge?
That can certainly be challenging. I mean, I'm a lawyer and I don't represent the AFNQL. Their counsel was at the hearing we just came from. So it is a bit of a political question, but, I mean, some of the things that we heard is that, what Quebec is offering is not as flexible as what the federal legislation offers, and that negotiations can be very long and protracted, and also Quebec wants to always have the final say, and that is a problem. And that has been historically a problem. That's one of the problems that we have raised, not just with Quebec, but with across the country, that, trying to get the provinces to really accommodate Aboriginal interests or Indigenous interests in child welfare, has been a long problem, and that's why we need legislation like this.
So can you talk about Quebec's legal right to challenge a federal bill and how exactly that works?
So, provinces have, and the federal government under our Constitution, there are divisions of powers, government, a government can challenge that, a provincial government can say the federal government's actually legislating in an area that's our area. And that's what Quebec's trying to say. They're saying child welfare is Quebec. But the feds are saying, yeah, sure, but Indigenous people is a jurisdiction that we have. And in this case, they're actually trying to use their jurisdiction to do good as opposed to being exploitative and harming. They're trying to fix the harms of the past, which things like the Caring Society case has really brought to light. So Quebec saying, no, nonetheless, that's going into our jurisdiction. I don't think their arguments are very strong on this point. And they're also trying to say that the recognition of the inherent right to self-government in this legislation is a problem, because when constitutional talks happened in the 80s and 90s, that was an issue that was sort of up for discussion. It was supposed to be sort of amended and put into the Constitution, and it never was, because the constitutional talks did not result in amendments. And so Quebec's saying, because it didn't happen in 80 and 90, then it's not part of the Constitution, and the feds trying to legislate is actually amending the Constitution unilaterally without our approval. And they're saying the only other way then that First Nations could get self-government is having to go to court individually, Indigenous group by Indigenous group, and proving it under the test that the court has set out for proving an Indigenous right, which is very, very complex and long. And so, no, and we've all said, no, Canada can pass law and to do this in a general way.
So we're talking about Quebec here, but could this legal challenge impact the application of C-92 in other places in Canada?
Oh, absolutely. Not a question. Like, if Quebec wins, if Quebec were to win, this would invalidate the act and its application across the country.
Wow. The first of these hearings have now wrapped up. What comes next?
Well, we're going to wait for a decision. The court reserved on Thursday at the end, and then we're going to get a decision. And it is, probably no matter what the outcome, the party who doesn't win will likely bring an appeal to the Supreme Court of Canada. So we're, I think, all expecting that the next round will be in the Supreme Court of Canada.
Much up in the air. Naiomi, appreciate you speaking with us on such an important matter.
Okay, you're welcome.